60 years. It's a long story, but it's
Judge, I see we're less than 5 minutes to starting. I see everybody's joining, so we'll hold the story and we'll get ready.
I'll put my mic on mute.
Thank you.
Okay, Leo, I'm good.
This way, this way.
Does everything look good?
I think so.
Okay, right.
Minutes. Be right back. Can I put this down now? I don't have to stand the whole time, do I? Not till I speak.
Laura, we can hear you.
Mhm.
All right, it's 10 o'clock. Let me see. Trying to see if I have everyone here. Looks like so.
Morning, Your Excellency.
Good morning. I think we'll get started. Good morning to everyone. I'm Judge Karen Fort Hood, Chairperson of the Michigan Judicial Tenure Commission. Pursuant to MCR 9.241, the Commission is conducting a public hearing in the matter of formal complaint number 102, in re Bruce U. Morrow, a judge of the Third Circuit Court in Wayne County, Michigan. This hearing is being conducted by video based on the ongoing COVID-19 pandemic. There's a court reporter participating in this session, and she is making a record of the proceedings. In addition, instructions for accessing the proceedings were posted on the Commission's website to allow for public viewing of the oral argument. The other members of the Commission are, and I would ask that each Commissioner acknowledge their presence and participation after their introduction. Honorable John Holsing.
Here.
Judge of the 20th Circuit Court in Ottawa County, elected by the Circuit Court judges. Judge Holsing also serves as the Vice Chairperson of the Commission. James Burdick, elected by the State Bar of Michigan. Mr. Burdick also serves as the Secretary of the Commission. Mr. Burdick, good morning. Honorable Monty Burmeister, Judge of the Crawford County Probate Court, elected by the probate judges of the state of Michigan.
Here, Madam Chair.
Danielle Cheney, one of two civilian members that is neither an attorney nor a judge, who was appointed by Governor Gretchen Whitmer.
Here.
Honorable Pablo Cortez, Judge of the 62A District Court in Wyoming, Kent County, elected by the Michigan District Court judges.
Here.
Siham Awada Jafar, the other civilian member of the commission who was appointed by Governor Whitmer.
Good morning, Judge.
Good morning. Thomas Ryan, elected by the State Bar of Michigan.
Present. Good morning, Your Honor.
Good morning. The Honorable Brian Sullivan, Judge of the Third Circuit Court, Wayne County, elected by the State Bar of Michigan membership.
Here.
Thank you all. Again, I am Judge Karen Fort Hood of the Michigan Court of Appeals, elected to the commission by my fellow appellate judges. Retired Michigan Court of Appeals Judge William Murphy, who has been retained by the commission to serve as commission counsel for this matter, is also viewing these proceedings.
Present, Judge Hood.
And we are now ready to proceed to the hearing. The record should reflect that the disciplinary counsel, Lynn A. Helland, is participating, as is the disciplinary counsel, Laura Weingarten. The respondent, Judge Morrow, is participating along with his attorneys, Donald Campbell and Elizabeth Jacobs. By way of background, on August 11, 2020, the commission issued formal complaint number 102 as to the respondent. The Supreme Court appointed Honorable Betty R. Widgeon, a retired Ann Arbor District Court judge, to hear the evidence. A public evidentiary hearing was held on 5 days between November 13th, 2020 and December 15th, 2020. The master issued her report pursuant to MCR 9.236 on February 9th, 2021. Respondent filed written objections to that report pursuant to MCR 9.240. And disciplinary counsel filed a brief in support of the master's report. Each party filed response briefs. Today is the date and time set for the public oral argument on the objections pursuant to MCR 9.241. The commission will refrain from asking questions during the oral arguments until I inquire of each commissioner if he or she has any questions at the conclusion of each presentation. Each side will have a total of 30 minutes to argue its case. As this matter is being conducted via video, I will notify you when you have 5 minutes of your argument time left. If the party arguing first wishes to reserve time for a rebuttal argument, please let me know when you begin to speak. Respondent has filed objections to the master's report, so you will have the opportunity to argue first, and you may begin.
Thank you, Judge Hood, and I hope everybody can hear me. I'm coming to you from Zagreb, Croatia. I had a pre-planned, prepaid trip to come here before this date and time was set. It's the first opportunity since the pandemic that I've had to come here to Europe to see my oldest child who's in studies here. So other than the risk of a charge of unauthorized practice of law in Croatia, I think that I'm okay with my connections. In case I'm not, as you have mentioned, Liz Jacobs is on the call, but also Trent Collier from my office. He wrote the brief. He's also on the line, and we have a plan if for some reason this does not work out for him to continue my argument as if he was me. For those of you who know me, you know that I don't spell so well, and the brief that was written by Trent Collier primarily with help from Liz and I. So with that, let me say that there's nothing I can do to improve upon that brief. There are some things that I'd like to highlight in my argument here, and I would like to reserve 10 minutes for my rebuttal, if I may, Your Honor. And I'll proceed. So the outline of what I'd like to address is as follows. There is a constitutional flaw and failing with regard to this process. These proceedings in particular involving Judge Morrow violated his due process. And the third area I want to address is that the basis for the finding of misconduct is due to errors of law and errors of fact. So I'll start with the first of the 3 points, and that is the process is unconstitutional. We have briefed this to you and raised it in our objections. It's based on Williams versus Pennsylvania. The outline of it is that there has been an evolution, a greater understanding of the constitutional standards that apply in administrative proceedings. Whizzer White used to say the court comes closest to illegitimacy in certain points. Let's just say that the court has moved farthest from illegitimacy in recent years. with the Williams versus Pennsylvania case, and the facts involve a judge who was also a prosecutor in the same case. In fact, had almost no actual involvement and only an administrative involvement. In fact, just a perfunctory approval role with regard to a case that ended up being a death penalty case. That case came before this same justice, then having been elected out of the prosecutor's office into the court, and in a decision that did not depend on this justice's ruling. I believe it was something like a 7-2 or 5-2 split in the Pennsylvania Supreme Court. The death penalty was upheld, appealed up to the United States Supreme Court, and then the United States Supreme Court used it as an opportunity to not change the law, but to explain the law better and to point out that you cannot be both part of the prosecution and part of the adjudication for due process purposes. And in the explanations we've provided, that applies to judicial disciplinary misconduct matters. You cannot, well, I'm going to say it this way, arguably, you cannot say to the Michigan Supreme Court and rule in this case that it was unconstitutional. However, you do have a constitutional role to play, and the court has highlighted in past decisions that it relies upon the JTC to do its constitutional obligation. I would say at the very minimum, your constitutional obligation when it comes to the Williams versus Pennsylvania issue, when it comes to the constitutionality of playing both prosecutor and adjudicator, is to at least say to the court that that's a valid argument. It should be a point on which the court makes a ruling, not just in this case, but it obviously has a wider effect. With regard to the second point that I raised, these proceedings in particular violated my client's due process rights. That, of course, turns on the issue of whether or not an in-person hearing is required both by 9.231 and by the constitutional due process rights. It's our position that it is required by both. I think it's plain in 9.231 that it requires that a place for the hearing be set. And as we've pointed out, a Zoom is not a place. In addition, that lack of in-person testimony, the lack of the opportunity to see witnesses testify appears to, and not surprisingly so, appears to have infected the decision of the master, which is not complete and not accurate relative to some of the credibility findings that were made, because she wasn't in the same room with some of the witnesses, in particular Anna Bickerstaff, but also Chief Bivens, Detective Kinney, and others that testified to an issue of determining the validity or invalidity of statements that were made, the trustworthiness, the lack of trustworthiness of some of the witnesses. So that brings me to my third point, which obviously is the significant part of our briefing and will be the significant part of my argument. And that is the issue of the errors of law and the errors of fact within the proceeding. The report fails to apply, consider, or even show any proper understanding of in re hocking. This is a little bit surprising because in my closing argument, and again, maybe it's because we weren't in the same room, but in my closing argument, I pointed out several cases, but I highlighted the Hocking case for why it is that there has to be a proper understanding and application of the concepts from the Michigan Supreme Court on judicial speech, especially as charged here. The factual arguments have to do with the lack of confrontation among other issues, but I'm going to spend some time now talking about the legal error. And to understand that is to understand Hocking. And I have to say, in their initial response, disciplinary counsel did not cite the Hocking. Yet it is clearly the controlling case. Hocking involved two separate and distinct matters and circumstances of judicial speech related to conduct, or yeah, I guess that's the way you would say it, speech related to conduct by a judge. Both instances in Hocking were on the record. Again, two different lawyers, each of them a woman. In each matter, the lawyer was treated with what was described as, by the court, quote, tasteless and undoubtedly, I should say, they were treated with language that was described as tasteless and undoubtedly offensive to the sensibilities of many citizens. The court pointed out, and this would be consistent with Morrow, that language did not include explicit abuse, or was not explicitly abusive, nor was there evidence of persistent misconduct, although it happened, as I say, in two different matters with two different lawyers. Contrasting Hocking with the proofs in this matter, we find one matter tried over about 4 days and 3 instances on 2 of those days. We find that in addition to the language at issue in conversation 2 and really just conversation 2, I guess, except for the conversation with Anna Bickerstaff alone, or the conversation that was alone with Ms. Bickerstaff and Ashley Chaffone. So that's the first conversation and the third conversation. There's nobody else around in those. And actually, I'll argue there's people around and who hear conversation number 1, but they were not part of the conversation. Then you have a second conversation, or a middle conversation, that's in chambers. And in that conversation, part of the direction of the comments by Judge Morrow is a third lawyer, William Noakes. And so unlike the Hocking case, where the statements are only and exclusively to lawyers who happen to be women, here, those comments were actually broader. And even in the first instance, there were people who heard those comments sitting literally right next to them while being spoken to. There was Detective Griffin, who happened to be male. So it's not exclusive. And again, Detective Griffin wasn't part of the conversation. So in it, also with regard to the other claims and other instances that have been brought up that weren't part of this case, aren't charged as misconduct and are improperly argued, as we pointed out in our response, is anything other than an attempt to rebut the overwhelming character witness, the discussion about armpit hair. Even in that conversation, Joseph Curley, a male, is there, and he, in fact, is the only one who was called to testify about that. So you don't have the dynamic necessarily that you have in Hocking, where the direction is exclusive and focused on what happens to be 2 women in that matter. And in fact, the armpit hair comment actually is more self-directed than anything else, because Judge Morrow talks about how he shaves his own armpits. In addition to that, another major contrast with Hocking is in Hocking, there was a response. There was an objection. There was a facial gesture and a noise that Prosecutor Moss made that drew the attention of Judge Hocking during his ruling. There was an engagement, even with the defense attorney, as the story is told within the opinion. That was the second, Madam Moss happened to be a prosecutor at the time. But there's, and the court went on to talk about how the judge had lost self-control. And that's what led to some of the comments that were made in Hocking. But here, The only conversations that Judge Morrow has are at invitation. And not just a mild invitation at that. You have Ashley Chiffone asks to be reviewed. She urges him to review her, critique her. We have Ms. Bickerstaff, who begins the conversation, the chat with Judge Morrow, as it was described by Ms. Chiffone, by inviting him, did I do better? How did I do that time? After the examination of the medical examiner. We have Ms. Bickerstaff at the third conversation, where only she and Ms. Chiffone and the judge are in the courtroom, who invites the second round of guessing on height and weight. Judge, I'm 5'3", if that's helpful, is what she said. So instead of having a situation where it should have been obvious and known to the judicial officer that this was offensive, that this was a problem, that this was an issue, Judge Morrow gets nothing but feedback that says, continue the conversation. Ms. Bickerstaff answers the questions that he asks at the table. Ms. Chiffone, by her own admission, parries to every thrust in the fencing with Judge Morrow in the back. And likewise, Judge, I'm 5'3", if that's helpful, is clearly an invitation. There's no reaction. And we know this because we know that Detective Griffin testified. He's there at the table. He hears the conversation. He is as close to Ms. Bickerstaff on her left as Judge Morrow is on her right. And yet he does not react. Nor does Ms. Bickerstaff turn to him, nor does he report that there is any reaction. Beyond that, we know that Ms. Chiffone shows up at the end of that conversation. This is the conversation, the part of the conversation that the JTC has focused on for its prosecution. The end, talking about the medical examiner's testimony, should end in a climax in terms of how the evidence is produced. Ms. Chiffone heard that. She was sitting mere feet, if not inches, away when that conversation takes place. She says so herself. I'm sitting there, I'm watching the two, I'm waiting because he's in my seat, and I'm just waiting for him to get out. You know, Judge Sullivan and others who've been in the Third Circuit Court Criminal Division, you know how close that bench is to that seat.
Mr. Campbell,
Yes.
I'm sorry to interrupt. You have 15 minutes left. 5 of
Thank you.
those are for your regular argument, and then 10 are for your rebuttal. So just to let you know, go ahead.
I appreciate that, Judge. Thank you. So there's not only is there no negative reaction, but there is an invitation that continues these conversations, very different from hockey. Also, we have Mr. Noakes in the back, and I want to talk about the factual errors. They include the fact of the timing of the conversation. The judge, the master, makes an offhand remark in her report that says, if Judge Morrow had believed that Ms. Chiffone was sexually inexperienced to engage in the conduct of these conversations in this area, would not have been proper. Again, the timing of according to everybody who testified, when Ms. Chiffone makes her statement about how she interpreted the information that was testified to, that is the last of that conversation. It doesn't continue past that. That's the end. In fact, it moves to the discussion of the bias from there. And that's the issue. And it wasn't a negative or derogatory, you are sexually unaware. It is just, you're coming from a particular place relative to how you heard this testimony. And the jury might not agree. You might consider that as a lawyer. That was the context of the discussions. She failed to put Ms. Bickerstaff's lies in context. She says in her report that she gives her credit for candor in admitting her failure to correct the mistake. There's no mistake here. She lied. She lied to Chief Bivens. She lied to Detective Kinney. She lied to the JTC's disciplinary counsel. She told a half lie there when she said, well, I didn't really tell Chief Bivens that. She did tell Chief Bivens that. And she said she hadn't read the report. When she testified at the hearing, she did testify that she read the report. So that solidify the proof of the lie to the disciplinary council, but she continued to say that she never spoke those words to Chief Bivens or to Detective Kinney. Detective Kinney did not have her notes, but could not deny that she had been told, as Chief Bivens recorded, that Ms. Bickerstaff said that Judge was hitting on her. And we know from Judge Bivens, because we have his notes and we have his testimony, and he said without reservation that that is what Anna Bickerstaff told him. That is the fact that brought us here today. That is the fact. I have not seen their report to you. You are part of the prosecution team up until they file that report. This is part of the Williams versus Pennsylvania problem. They gave you a report and said, this is why we should prosecute Judge Morrow. You know what I don't know, but I am sure of. They told you the same thing they put in that complaint, overtly they inappropriately, intimately close. They played the race card in your report as much as they did in that complaint. That's why we're here, because they told you that Judge Morrow was a sexual predator. That was untrue, through and through, no evidence. In fact, we have defeated the evidence of that. I believe my time is up during my argument. I have much more to say, but I have to hold it.
All right, well, you'll have 10 minutes left for rebuttal.
Thank you, Your Honor.
Thank you, Mr. Campbell. I will now inquire whether any commissioners have any questions for Mr. Campbell, and I will proceed in alphabetical order. Commissioner Burmeister?
Thank you, Madam Chair. I have no questions.
Commissioner Burdick?
I read lips, Your Honor. I believe you said no questions.
Commissioner Cheney?
Thank you, Madam Chair. No questions.
Commissioner Cortez?
I have no questions. Thank you.
I want to
Commissioner
clarify if I
Hulse?
may, Your Honor. I was I was on mute when I said, even only the lip reader knew what I said, which was, I also have no questions. Thank you.
Thank you. I wondered what happened. Okay, thank you.
Well, now we know what happens when Don Campbell is watching us.
Very good. Commissioner Hulsing?
No questions, Madam Chair.
Commissioner Jafar?
No questions, Madam Chair. Thank you.
Commissioner Ryan?
I have no questions, Madam Chair. Thank you.
And Commissioner Sullivan?
No questions. Thank you.
Very good. And I have no questions as well. Ms. Weingarten, you may proceed.
May I have a moment, please?
You certainly may.
I need my presentation on Word. How do we get it?
Let it go to.
Chairperson Fort Hood, I'm ready.
All right, you may proceed. Thank you.
Good morning, commissioners. We addressed the respondent's argument that the process was unconstitutional and that there was a due process violation in our brief. We rely on our brief. Mr. Campbell continues to rely on hockey. We distinguish that case in our brief, and we also rely on our brief. It is factually distinct from the facts of this case. The respondent admits he said and did almost all of what Mr. Bickerstaff on the phone heard him say and do. The only real questions are whether the respondent's words to these women were misconduct, and if so, what sanction he deserves. In count one, the respondent's words to Ms. Bickerstaff were misconduct. He asked Miss Bickerstaff, when a man and a woman start to get close, what does that lead to? You start with holding hands, rubbing elbows, kissing, foreplay, and then that leads to sex. Would you want foreplay before or after sex? You want to tease the jury with the details of the report, and that leads to the climax, which is the cause and manner of death. Respondent knew ahead of time that what he was going to say might make her blush. He even said so. At the time he spoke explicitly about sex to Miss Bickerstaff, he had no prior relationship with her. He knew she was young and inexperienced. She was 27 years old and had only been a prosecutor for a year and a half. He placed himself intimately close to her, with the arms of the chairs touching and their faces 12 to 18 inches apart, and his eyes locked on hers. He knew, or should have known, that as a young prosecutor, she was a captive audience and did not have the freedom to leave or to end the conversation. The respondent claims he didn't mean to use the word climax in a sexual context. Think about that for a minute. After talking to Miss Bickerstaff about how a relationship develops and discussing foreplay, he told her, quote, "You want to tease the jury with the details of the report, and that leads to the climax, which is the cause and manner of death." And he says he did not mean it sexually. He would not have been concerned about making Miss Bickerstaff blush if he had meant his words in a non-sexual way. And if he really believed his words and analogies were appropriate, why didn't he say them from the bench for all to hear? The fact that he feels it's necessary to deny the obvious shows that he knows it was misconduct for him to say what he said. He claims he was trying not to embarrass her in public, but we know that's not true because he had already critiqued her and Miss Chiffone. He didn't care about embarrassing them. And his answer to the complaint claimed that anyone was welcome to hear the discussion. That makes no sense if he were trying to shield Miss Bickerstaff from embarrassment. The respondent knows how to teach and provide feedback without using sexual words and analogies. For example, he provided feedback to Mr. Curley, his assigned courtroom assistant prosecutor, during Mr. Curley's 18 months in respondent's courtroom. During those 18 months, the respondent never sat intimately with Mr. Curley. He never used sexual analogies with Mr. Curley, and he never used the words tease, foreplay, climax, or crescendo with Mr. Curley. He chose to use those words with Miss Bickerstaff because she is female. It's hard to imagine him having that conversation with a male prosecutor. The respondent can't claim he didn't know any better. In 2004, the State Court Administrative Office warned him, "It is inappropriate to discuss matters of a personal nature with staff unless that individual is an acquaintance or friend." SCAO further warned the respondent to refrain from initiating or participating in inappropriate conversations with staff regarding topics of a personal nature. That's Disciplinary Counsel Exhibit 11. At the same time, this commission cautioned respondent against engaging in conversations with court staff which are of a personal or intimate nature and which may be regarded as offensive or embarrassing. That's Disciplinary Counsel Exhibit number 10. Since the respondent was warned by this commission in 2005, public awareness about sexual harassment by people in positions of power has grown stronger. And people in positions of power are on clear notice that sexually harassing words and conduct are unacceptable. Respondent must have had his head buried in the sand not to know this. The only reasonable conclusion is that he purposely chose to ignore the warnings about how to interact with women. Respondent argues he was simply educating Ms. Bickerstaff about how to conduct a better direct examination. But the master found that his explicitly sexual way of doing so was not courteous, respectful, or dignified, and that he violated canons 1, 2B, 3A14, and 3A3. The evidence supports her findings. Count 2 is about respondents' repeated use of sexual analogies and sexual language when in chambers with Ms. Chiffone, Ms. Bickerstaff, and Mr. Notes. The respondent believed that Ms. Chiffone's voir dire was bad. So he created a voir dire question that would help him determine if a woman would sleep with him on their first date. He also believed that there was no need to present DNA evidence. Ms. Chiffone explained her reasons, and his response was, quote, all it shows is that they fucked, unquote. He could have said all it shows is that they were intimate or they had sex, but he chose to use the very graphic word fucked. He asked Ms. Chiffone for her definition of non-traditional sex. They discussed defendant Matthews' testimony. The respondent shared his belief that Matthews and the victim had sex, quote, doggy style. He could have said it in a more professional, less crass way, but he chose not to. He laughed about the defendant's explanation for not having sex the normal way and joked about the size of defendant's penis and what the defendant thought of the size of his penis. The respondent was talking mainly with Ms. Chiffone at the time he said these things to her. He had no prior relationship with her, except that she had last practiced in front of him when she was an intern 9 years earlier. The prosecutors were again a captive audience. They were not free to leave and not free to object. They were captive because it's very hard for a young prosecutor or any lawyer to walk out on a judge. They were also captive because they didn't want to irritate the respondent. He was considering a directed verdict motion for the defense, and if he granted, their case would be dismissed. Just like the respondent claims to be teaching Ms. Bickerstaff about how to do an exam, he argues he was only trying to critique and educate Ms. Chiffone about how she tried the case. But just as with Ms. Bickerstaff, he could have chosen non-sexual ways to do so. He made the choice to be sexual and risque and offensive. When respondent critiqued Mr. Noakes, he didn't use sexual examples and analogies. Clearly, he knows how to provide feedback to male lawyers without using sex. There was something about having young female prosecutors that inspired his use of sexually explicit language. Respondent says that because sex was a part of the case, he was free to use sexual words and analogies in chambers, but he was not. The fact that sex occurred before the woman's murder did not entitle respondent to use a sexual analogy free-for-all. Mr. Campbell argues that the use of the word fuck or doggy style is not misconduct and that people use those words in everyday conversation. He wants you to consider each word respondent said in isolation. You can't take each word in isolation. You have to consider all the words he used in the context in which they were said. The totality of what he said is what constitutes misconduct. Mr. Campbell also argues that legal writings are replete with reference to sex, and there is nothing wrong with a judge using words or thoughts that are sexual in his conversations. There is a big difference between writing words and thoughts or saying them on the record while on the bench and saying them face to face to young women over who respondent had authority in an intimate or private setting. The master found respondent's comments to be unprofessional discourtesy, and the evidence supports that. His comments in chambers violated canons 1, 2B, 3A14, and 3A3. Count 3 is about respondent following the women out of his chambers to their table in the courtroom, looking them up and down and commenting on and asking about their height, weight, and muscle mass. The master found respondent's actions to be personal, intrusive, and unprofessional. Respondent again shows that he knows this is wrong by offering an excuse that is obviously false. He claims he was only discussing people's biases, yet he never gave the women that explanation, and assessing his height and their height and weight and muscle mass has nothing to do with bias. And his discussion with jurors about bias took place 3 days earlier. His excuse is nonsensical. Mr. Campbell insists that there is no evidence that respondent overtly eyed the women. The women both testified that respondent looked their bodies up and down. This was during a discussion about their height and weight and his intention to assess Ms. Bickerstaff's muscle mass. Their testimony is evidence. Mr. Campbell next argues that the charges in count 3 and the women's testimony are racially motivated. That is an outrageous accusation. There is absolutely no evidence of that. Mr. Campbell made an issue of race before the hearing and after the hearing, but not during the hearing, when he had a chance to develop testimony about whether the allegations were motivated by race. The women were not asked any questions about the respondent's race or how they would have reacted if a Caucasian judge had used the same words or actions respondent did. Race was not raised until the 4th day of the hearing, and it was raised by defense counsel Ms. Jacobs when she asked a defense witness about the race of a different judge. Then Mr. Campbell argues that the women sexualized respondents' words and conduct, but none of the witnesses did that. They simply testified to the facts. Respondents' scrutiny of the women's bodies violated Michigan Court Rule 9.202B1D, Canons 2A, 2B, 3A14, and 3A3. Respondent's treatment of Ms. Bickerstaff and Ms. Chaffone, in light of his history of misconduct, deserves a strong sanction. He has a persistent pattern of misconduct that includes his actions in the early 2000s that gave rise to the letters from SCAO and this commission in 2004 and 2005. His multiple acts of misconduct for which he was suspended in 2014 are also a part of the pattern of conduct. The Court of Appeals reversed several of his decisions in those cases. His pattern of misconduct includes his ex parte conversation that caused this commission to admonish him again in 2018. The admonishment was just 6 months before he had this ex parte conversation with Ms. Bickerstaff in this case. And he committed misconduct in 2018 when ruling on a motion to suppress evidence of cell phone records in a drug case. In a case that had nothing to do with sex or sex crimes, the respondent posed a hypothetical question to a female prosecutor. Would I have an expectation of privacy if I were to have sex with a man in the stall of a restroom? The respondent again committed misconduct in 2019 when he asked a female prosecutor who wears a hijab what color her armpit hair is, and he shared with her that he shaves his own armpits. And then the present case, which involves 3 instances of sexually inappropriate conduct in 2 days. So between early 2000s and June of 2019, the respondent used inappropriate personal, sexual, and intimate language with 5 different women. We didn't cite this case in our brief, but it's applicable here. In Ray Moore, 464, Michigan 98, it's a 2001 case. The court held that respondent showed a pattern of misconduct when he had prior admonitions, a public censure, and repeated criticisms and reversals by reviewing courts. He had been warned repeatedly that his conduct was improper. Like in Ray Moore, respondent has demonstrated a longstanding pattern and practice of misconduct. His decisions have been criticized and reversed on appeal. Another factor that you should consider is that the respondent's misconduct took place on the bench. I have one correction to our brief in support of the master's report. In Ray Adams did not say that respondent's conduct was on the bench conduct, but the 2 other cases cited in our brief support our argument that respondent's conduct was on the bench. In Ray Susan Charnowski, the court held that assigning her boyfriend an attorney to represent 56 indigent defendants was on the bench conduct. And in Ray Bargland, the court held that delays in ruling on cases and the failure to respond to SCAO inquiries were on the bench conduct. You should also consider that respondent's offensive words were premeditated. His first statement to Ms. Bickerstaff was, "I'm going to come down there to talk to you because what I have to say could make you blush." He knew what he was going to say ahead of time, and he knew the impact it would have, and he did it anyhow. The next day, during the in-chambers discussion with Ms. Chaffone, several things he said were sexual. As Ms. Chaffone testified, it felt like every example that he gave always kept going back to sex or the way someone looked. It felt like they all kept every example or teaching moment he maybe tried to have about anything always went back to a sexual explanation. Regarding the discussion about the women's height, weight, and muscle mass, the respondent admits in his answer to the complaint, paragraph 30, that it was a continuation of the in-chambers discussion. After leaving his chambers, he could have taken the bench. Instead, he deliberately followed the women to the prosecution table to initiate the conversation. He had time during the walk between his chambers and the prosecution's table to change course, but he chose not to. Even during the discussion, when Ms. Chaffone reminded him it's not polite to ask a woman her weight, the respondent asked Ms. Bickerstaff about her weight. None of this was spontaneous. You should also consider the fact that respondent made his comments to Ms. Bickerstaff and Ms. Chaffone because they are women. There is no evidence that respondent said sexual things to males. The only evidence is to the contrary. Respondent critiqued Mr. Curley at least 15 times over 18 months. They never sat closely. They never looked into each other's eyes. The respondent never made sexual analogies, and he never used the words foreplay, tease, crescendo, or climax. The respondent critiqued Mr. Noakes and didn't use sexual examples. Mr. Fishman and Mr. Edison, who are respondents' long-term friends and character witnesses, testified they never heard respondents speak discourteously or disrespectfully to anyone. Yet he spoke in overly intimate ways with Ms. Bickerstaff and Ms. Chaffone, and the female prosecutor who wore the hijab, and the female prosecutor with whom he spoke about having sex with another man. Ask yourselves if respondent would have said these things to male lawyers. It's hard to imagine he would. He only said these things to the women because they were women. Perhaps nothing better captures the respondent's attitude toward women than this. After Bill Cosby was convicted of committing sex crimes against a woman he had drugged, respondent had a prominent picture of Cosby on his courtroom wall. The picture was plainly visible to jurors, sex crimes victims, and the public. In addition to the Brown factors, there are 3 other aggravating factors that are very significant in this case. First, the respondent has not accepted responsibility for his words or conduct, or even acknowledged that they were wrong. Rather, he has doubled down on his claim that they were appropriate. Second, the respondent has not shown the slightest bit of remorse. Finally, the respondent has already had significant contacts with the judicial disciplinary system, and those contacts have not corrected his behavior. So what should be the sanction? It should be removal or suspension, and preferably a suspension that carries him through until the end of his term at the end of 2022. In order for you to recommend an appropriate sanction, you need to know what sanctions were imposed in similar cases. There are 3 Michigan cases that have facts similar to these here. 2 of them involve sexual harassment, and 1 involves sexual harassment and unconsented to touchings. In Ray Iddings, respondent created a hostile work environment with multiple acts of sexual harassment. He had no disciplinary history, and he self-reported his misconduct. He expressed remorse, he sought to correct his behavior, and he consented to a 6-month suspension. In Ray Serbas, Judge Serbas drew sexually explicit graphic pictures of breasts and a penis and attached them to court files on 2 occasions. He also commented to an employee while they were at a retirement party about the small chest size of another employee. The next day, he attempted to apologize to the employee about whose body he commented. Unlike respondent here, Judge Serbas did not direct his actions or words to any specific victim. Unlike respondent here, Judge Serbas had an unblemished 37-year history as a judge. Due to that history, the Supreme Court only censured him. In the matter of Honorable Avram Davis, Judge Davis made sexually inappropriate comments, kissed a staff member on the lips, and grabbed her private areas without her consent. The commission recommended that he be removed. That was in 1989. As mentioned in our brief in support of the master's findings, Other states would also remove respondent or give him a lengthy suspension for this kind of misconduct. So how does the respondent's conduct compare to the judge's conduct in the Michigan cases I've cited? Respondent has a lengthy judicial misconduct record, unlike Judges Iddings, Servas, and Davis. He was warned about intimate conversation with those under him by SCAO and the commission in 2004 and 2005. He had already been suspended for 60 days. That was in 2014 for his misconduct in 8 cases. Apparently, that suspension did not teach him anything. He was admonished by this commission in 2018 for having ex parte communication. The respondent had been counseled, educated, and instructed in the past about the same things for which he is before you now, unlike Judges Iddings, Servas, and Davis. The respondent ignored the counseling, education, and instruction he received in the past, unlike Judges Iddings, Servas, and Davis. There is evidence that respondent said inappropriate, intimate, and sexual things to female prosecutors in 2018 and 19 that are uncharged acts of misconduct, unlike Judges Iddings, Servas, and Davis. Respondent had face-to-face conversations with Ms. Bickerstaff and Ms. Chaffone, and his comments were much more offensive, disrespectful, and discourteous than were the pictures that Judge Servas drew and attached to files. Respondent has not apologized to the women, like Judge Servas tried to do with one of the women he offended. Respondent has not expressed remorse, like Judge Iddings did, and instead, respondent still believes that he did not do anything inappropriate. He simply doesn't get it and never will. Respondent has not tried to correct his behavior like Judge Iddings did, and he did not self-report his behavior like Judge Iddings did. Respondent thinks he didn't commit misconduct, so he shouldn't be sanctioned at all. He believes if he is sanctioned, it should be minimal, like public censure. Mr. Campbell omits from his brief that the judges have been removed for things other than dishonesty, false statement, perjury, fixing tickets. In our brief in response to respondents' objections to the report, we list cases where judges have been removed for other things. Respondent's plea of leniency rests on a selective list of precedent, which is like comparing trucks to apples. He omits all but one, the least serious case, involving sexual misconduct, sexual harassment, or sexually charged words or actions. Disciplinary counsel recommends removal or a long suspension that will keep respondent off the bench until December 31st, 2022, when his term expires. Thank you.
Thank you, Ms. Weingarten. I will now inquire whether any commissioners have any questions, and I will once again proceed via alphabetical order. Commissioner Burmeister.
Thank you, Madam Chair. I have no questions.
Commissioner Burdick.
Thank you, Madam Chair. I also have no questions.
Commissioner Cheney.
Thank you, Madam Chair. No question.
Commissioner Cortez.
Thank you, Your Honor. I have no questions.
Commissioner Hulsing.
Madam Chair, I have no questions.
Commissioner Jaffer.
No questions, Madam Chair. Thank you.
Commissioner Ryan.
Thank you, Madam Chair. I have no questions.
Commissioner Sullivan.
No questions.
Very good, and I have no questions as well. Do any commissioners have any further questions? Again, if you have any questions, commissioners, signal to me and I will call you by name. All right, seeing none, Mr. Campbell, you have 10 minutes of rebuttal time. You may proceed.
Thank you, Your Honor. On rebuttal, in terms of what was said, Ms. Bickerstaff being legally inexperienced now is the argument. We went over her resume at length during the proceedings. She had something close to 8 years already at the Wayne County Prosecutor's Office due to her internships, due to her practice time as a student. That doesn't fly. The corrections and admonishments and the discussions with Curley versus Bickerstaff. Remember, this didn't start as a conversation where Judge Morrow went to a technique of teaching that involved discussion of what would be considered sexually related content. It started with reminding Ms. Bickerstaff on several witnesses, hey, you're saying the word "and" a lot. Again, when she asked for a feedback on it. And he said, you might want to keep that in mind. And as we demonstrated, I think she did 3 witnesses in between, or 3 total. And she averaged more than 70% of the time she began a question with the word "and." She did it again for the medical examiner. And then she also did a poor job of concluding that testimony. And she acknowledged when she testified in this proceeding, he's right about the advice he gave, and she's going to follow it. More importantly, unlike the "and" advice that was direct, express, and forgotten as soon as it was given, this was remembered, applied, and frankly, she said she understood the concept now of ending it. It's how she intended to end her examination, but failed to do so on her own. And that's, again, you could read that testimony. With regard to the hard to imagine him having this conversation with male attorneys, the JTC itself gives you an example of that with what they describe as sexually explicit conversation about the armpit hair. And that's with Joseph Curley, among others, or with another lawyer there, but he's there. So he did have that. Mr. Noakes is there in the back. Now they want to say, well, he wasn't talking to Noakes. And that was the position of the 2 female prosecutors. As I said in the brief, they pretended like he wasn't there, and the JTC completely ignored him and didn't even call him as a witness. Here's a witness, an independent witness to what was said in that room. And they don't even call him as a witness to this. We were left to do that. With regard to the quote unquote inappropriate language, only inappropriate language if you move the line that Hocking has established. Other than that, it's not inappropriate. Finally, with regard to the question of the words used by the judge in chambers, as we presented in the Cohen case in our brief, sometimes, especially in the heat of the argument, and Ms. Chaffone testified, the judge was frustrated in the conversation. He got more frustrated. We gave you those citations. But Cohen talks about how sometimes language is more emotive than cognitive in terms of how it is expressed. And by the way, one example of that is talking about the genital size of the defendant. That's a comment which highlighted and showed an extreme version of what Mr. Noakes had said. And Mr. Noakes said he took it as that. He took it as a critique of what he had argued. So that was not directed at either of the prosecutors. That's false. And again, even the master doesn't get that right. And lastly, with a few moments that I have left, let me conclude my rebuttal, which in a manner that may be more emotive than cognitive, but with a short story. When I was 6 years old, I attended the first grade at St. Rose School at Kirchville and St. Jean on the Lower East Side in Detroit. I was one of 3 white kids in a classroom of 40. Our teacher, who was a nun, came in on music day and taught a new song to the class and said, "You 3, me and the other 2 white students, you don't need to learn this." Fortunately for me, my first grade teacher came in during one of the performances of the song, Miss Lassiter, by the way, Miss Lasker, I'm sorry, Carol Lasker, I think was her first name. Never called her by her first name, of course. But she went on to become somewhat famous in Detroit education. But this, I believe, was her first year teaching, and she came in the room and she saw us not singing, and she made us sing. And I will tell you, I learned more in that moment than I would for the next 20 years of my education. That song was "We Shall Overcome." Race is not limited to the few to make a comment about, to raise as an issue. I learned that day that there's a place for me when I see racial injustice. And one of those moments has been this complaint in this matter. And frankly, the arguments continued here by disciplinary counsel. In your name, they have presented this. That's outrageous. I have nothing further.
All right. Very good. Thank you, Mr. Campbell. Do any commissioners have any further questions? If so, please signal and I will call you by name. Any commissioners, you have any questions? All right. All right. Seeing none, are there any further issues? Very good. There being nothing further, the commission will take this matter under advisement and will issue a written decision and recommendation. That decision and recommendation will be a public document and it will be posted on the commission's website. The commission thanks counsel for their well-written briefs and their thoughtful arguments here today. The hearing is adjourned. Thank you all.
Thank you.
Thank you. Commissioners, you'll switch to the next phase.
We need to disconnect and then reconnect with the new number.
Okay.
I'll get